Start. Para. The state of Maharashtra is in appeal before us, challenging the order of the Division Bench of Bombay High Court dated 18/8/2009, which has allowed the writ petition of the respondent while setting aside the order of the Deputy Superintendent of Stamps Maharashtra (appellant number 2). We have heard learned counsel for the appellants and learned senior counsel for the respondents. National Organic Chemical India Limited was incorporated with an initial share capital of rupees 36 crores in 1992. It increased its share capital to rupees 600 crores and accordingly paid a stamp duty of rupees 1 crore 12 lakh 80,000 as per Article 10 of Schedule 1 of the Bombay Stamp Act 1958. At that time, the provision read as under. The state of Maharashtra (appellant number 1) on 2/8/1994 amended Article 10 and introduced a maximum cap of rupees 25 lakhs on stamp duty which would be payable by a company. The amending notification is reproduced below in part. Subsequently, the respondent passed a resolution for a further increase in its share capital to rupees 1200 crore and paid rupees 25 lakhs as stamp duty when it filed its notice in form number 5 pursuant to section 97 of the Companies Act 1956. However, according to the respondent, this was done inadvertently and it was soon realized that stamp duty was not liable to be paid by them since the maximum stamp duty, which was of rupees 25 lakhs payable on articles of association as per the provisions of the Stamp Act, had already been paid by them in 1992. Consequently, the respondent wrote a letter to appellant number 2 seeking a refund of the payment of stamp duty of rupees 25 lakhs. Para. This request was turned down by appellant number 2, wide order dated 20/1/1998, where it was stated that whenever the authorized share capital of a company is increased, stamp duty is payable on each such occasion at the time of filing of form number 5, and it is not a one-time measure. Aggrieved, the respondent filed a written petition before the Bombay High Court challenging the aforesaid order and seeking refund of stamp duty of rupees 25 lakhs with interest paid by them inadvertently. Para. The Bombay High Court, after hearing the parties, concluded that form number 5 is not an instrument as defined by section 2 of the Stamp Act and that stamp duty can only be charged on articles of association where the maximum duty payable as per the amendment had already been paid by the respondent. The High Court allowed the writ petition and directed the appellant to refund stamp duty of rupees 25 lakhs along with interest 6% per annum. Para. Learned counsel for the appellants submit that a company increases its share capital by sending a notice in form number 5 as per section 97 of the Companies Act. Thus, he contends that every time a company increases its share capital, it is a separate taxing event and stamp duty is liable to be paid irrespective of whether the maximum amount payable under the section has previously been paid. The learned counsel further relies on section 14A of the Stamp Act to contend that any material or substantial alteration in the character of an instrument requires a fresh stamp duty according to its altered character. Stop.